My name is Eva Micheler, and I am a professor at the London School of Economics at the law school. Um, and I work in two core areas. One is core corporate or company law, and the other areas is the law of intermediated securities. And I've been working on intermediated securities since 2004, so a very long time. And I've also been interested in distributed ledger technology, and I've done work on distributed ledger and blockchain technology um, since 2014, and that's well before the ongoing hype on the technologies. I've been working in this area from the ground floor onwards. My job today is to speak about the interface between the Hague Securities Convention and the technology, and I've been asked to give my view on um, how on the place the Hague Securities Convention has in against the background of this technological development. Let me begin by briefly reminding ourselves as to the purpose and the role and the content of the Hague Securities Convention. So there has been a shift from direct holdings and a look-through approach. So a situation where, depending on the jurisdiction, investors' names were either entered into the issuer's register or they held securities on a look-through basis, so securities that were perhaps immobilized and they were considered to be owners of those securities. And the computerization has then led to a situation where in some, not all, in some jurisdictions, investors have become considered to hold intermediated securities rather than securities directly, and a no look-through approach has emerged, and that's, for example, in the UK, but also in other jurisdictions that have a common law heritage. And that's a situation where investors are no longer considered to be owning underlying securities, but rather having a right in a right held for their benefit. The question then is, what about international holdings? So how do we bridge this gap where there are different jurisdictions with different approaches, and how does private international law work? And as you know very well, one model is the PRIMA model, so that's the place of relevant intermediary approach model, and that's a model that's used, for example, in the European context. So there are a number of directives. The settlement finality directives is an example of that, where the PRIMA model is used. The Hague Convention has gone down a slightly different path. So it adopts choice of law, and the caveat is, or the taper is, that the agreement between the account provider and the account holder can choose the law that applies to certain rights arising out of that relationship, or certain rights in relation to the securities, provided that the account provider has a qualifying office in the jurisdiction the law of which is chosen. So there's a sort of qualifying office caveat there. The Securities Convention, the Hague Securities Convention, has been very, very successful in that it was adopted very quickly. So it didn't take very long for negotiations to succeed. But then what happened, it hasn't been widely adopted. Now I've put here the three jurisdictions that have adopted the convention: the US, Mauritius, and Switzerland, and those are very important jurisdictions. But it's a slight disappointment that it hasn't had wider appeal. So one question that is raised in the literature is there too much choice of law? Is the convention leaving too much room for the parties to determine which law applies? And another so there's a question of should we revisit the convention? And then, of course, there's another reason to look at it, and that's the arrival of distributed ledger and blockchain technology. And the question that I'm going to give a view on is, would it make sense to revisit the Hague Securities Convention against this background? Now, of course, you're probably aware that the Permanent Bureau has made a statement that they believe that the review of the convention is desirable. Now let's then move on to the technology, distributed ledger and blockchain technology. Let me begin by saying the taxonomy is unsettled, and that applies to the lawyers, the legal space, as well as to the computer scientists. So it's a work in progress. It's an ongoing development, and so we're not yet settled on how to describe phenomena. So the technology is in development. There's a very good document by the Permanent Bureau of February 2020, a preliminary document number 28, and there some quite succinct and helpful definitions are being used. And in that document, distributed ledger technology is described as the decentralized storing and validation of data. And blockchain is described as a database that is recorded and updated through distributed ledger technology. So what are we talking about? Very briefly, we're all familiar with the land register, where there's a central provider, and that central provider records all transactions relating to land and who owns land, who has rights in relation to land. And that's done through a trusted central provider in all jurisdictions that I know of. And there are, of course, access points through that database, and that could be there's many of those. They're in law offices, they're in courtrooms, the database is accessible widely, also through the internet. And that's a way of us organizing a central database. Now, a distributed ledger then has not one keeper of the register, but several. And these providers then update the ledger through what is called a consensus mechanism. So this is what we mean by decentralized. So there's more than one operator that holds and updates the database, and they agree through a consensus mechanism when an update happens. And then there is some terms that are used. So node, for example, is a name for someone who maintains the database. And then there is another term, public key, and that is an alphanumeric account number. So nothing particularly difficult. One thing that's fascinating in this area is this is highly digital and has is associated with very interesting and computer science questions. But the terminology mirrors tangible objects. So we talk about nodes, we talk about keys rather than accounts. So that's a sort of fascinating observation about this area. And then the private key is another word for a password, also alphanumeric, so consisting of numbers and letters. The role of the convention. Now, there is a possibility that the technology could replace the current market infrastructure, and it could replace the whole infrastructure, the infrastructure for trading, for clearing, for settlement and holding of securities such as shares and bonds. And that is something that I've heard talk about since 2014. And there's a good number of people who believe that this could happen. but it hasn't happened yet. So the current systems for trading and settling securities continue to exist. And in fact, Australia is a jurisdiction where they, for some time now, have been working on a DLT-inspired system as a replacement for chess, and they continue to work on it. So it's an ongoing project, and it has taken some time. So there is a question of whether this potential can be realized. But of course, disruptors can always emerge, and it is certainly the case that a lot of money could be saved for a lot of people if trading, clearing, settlement, and holding of securities was organized in a different way. So there is potential there, and disruptors can emerge. So that's one reason why it would be a good idea to look at relook at the convention in light of this technology. But there's another and perhaps even more important reason, and that is the reason that the original peer-to-peer approach of Bitcoin and other cryptocurrencies is disappearing. So when I first looked at this area, it was still the case that individuals from their homes were operating as nodes, and they had a computer, and with that computer they were participating in the mining of Bitcoin. Now that world has fully and completely gone. It is now the case that Bitcoin mining operations, and I'm sure you've seen images of them, are in places that are very cold, where they don't need cooling, and it's a very large warehouse type spaces with computers stacked one over the other. So it's no longer a peer-to-peer environment for individual, computer scientists who have an interest in this area. So that has disappeared. And with that, intermediation has arrived. So we are finding that people no longer have the Bitcoin blockchain on their computers. They rather use the services of providers to hold their coins. And these providers are referred to as wallet providers, and wallets are also sometimes provided by exchanges. And here again, fascinatingly, we see the term wallet provider. So this is again a word for a very tangible object, used in a space that is on the extreme end of or is very digital. So that's I think a fascinating question as to why is this? Why are we using these words? But that's a sort of side question. So the main point is that intermediation has arrived, and the providers of accounts are referred to as wallet providers, and sometimes also exchanges provide wallets. Now there's a substantive law question, very important one, and that is, what are these relationships from a legal point of view? Are they contract? The relationships between the providers of the wallet and the investor, are they a contract? Are they a trust? Is this property in some form? And that's a question that is, of course, the answer to that is informed by what exactly has the wallet provider promised. And then also there's, of course, a choice of law question as to which law applies to determine this. So I think what a revision or a further work on the convention should be doing is doing more than just looking at the potential of securities being traded and settled and cleared, or traded, cleared, and settled through distributed ledger technology. I think it should also be looking at the fact that crypto assets such as cryptocurrencies, non-fungible tokens, digital assets, and potentially then including crypto securities, are becoming increasingly intermediated. And then, of course, the work that has already been done in the convention could be expanded and could include questions of intermediated holdings in relation to those assets. And in this regard, I would draw a distinction between investors who have access to their private key and investors who don't. Now remember, the private key is the password which is required for someone to transfer a digital asset that is held through a blockchain um, from one account holder to another, or from one public key to another. So, and I would say this distinction needs to be drawn. Does the investor concerned have access to a private key or not? If they do have access to a private key, either because it's kept at home or because they have a right to request delivery of that private key, then I would say they hold directly. And then that would be outside of the convention, or maybe not. Maybe this is then combined, but it's certainly a direct holding. And then the other form are investors who do not have access to a private key, and I would say they can be considered to hold indirectly. And then the question arises, what is it that has been promised to them? I would predict that indirect holdings, or I would observe that indirect holdings are becoming the main model. And an interesting question is, why is that? I think it suits wallet providers because they can operate on a fractional reserve model, so they can modify what exactly they promise their account holders. Do they promise them that sort of a right to a key, or do they promise them a form of investment where there's not a sort of direct correlation between any underlying asset? And so that's something that wallet providers can offer. Of course, investors do not necessarily want to look after private keys or passwords. That's, that can be hard work, and you can see investors not having an interest in doing that. And I think also not all investors have the digital literacy to understand the relevance of private keys. So we're seeing a space that used to be populated by highly digitally literate people with a computer science background or a strong interest in computer science. And now the appeal is much broader. Now we are also seeing a lot of investors that don't have that digital literacy, and they may not be aware how relevant and how important private keys are. So I think indirect holdings are becoming a main model. And then the convention, of course, is a good starting point through which private international law questions in relation to intermediated holdings of cryptocurrencies, NFTs, and other digital assets are held. And I think that's worth doing now, because those forms of holdings exist and they're very international. And it is useful to start work on finding a way of conceptualizing this and finding ways of identifying a private international law rule that is suitable against this background. And of course, the Hague Securities Convention is a useful starting point. Yeah, so I think that's it. This is sort of my view on how the convention could be a starting point to look at an area that deserves looking at. And it's there's sort of boom and bust in this space, but it looks to me like the appeal of the technology isn't going away, and investors continue to have interest in this. So it makes sense to look at it from a private international law perspective. Thank you.